Welcome back to Understanding Tribal Treaties and Reserved Rights. In our last episode, The Unique Status of Tribal Nations, we explored the concept of tribal sovereignty. In today's episode, Treaties, the Supreme Law of the Land, we delve into the complex topic of tribal treaties. By the end of this episode, you will be able to explain the historical context and significance of tribal treaties, recognizing their importance in defining rights, establishing responsibilities, and protecting tribal lands and resources. Recall that the United States supports tribal sovereignty and self-determination for, and has a trust relationship with, all the tribal nations it recognizes. Let's start with the basics. What exactly are treaties, and where do they fit within the federal government structure? Treaties are legally binding formal agreements between two or more sovereign nations. The Constitution, Article 6, states that treaties, like federal statutes and the Constitution itself, are the supreme law of the land. Some important points to remember from Module 1. Indian tribes are sovereign nations with the inherent authority to govern themselves. The United States has entered into binding treaties with many Indian tribes. Although not all tribes have treaties with the federal government, the United States acknowledges and supports the sovereignty of all tribal nations it has recognized and with whom it has a unique trust relationship. The United States has a trust responsibility to all such tribal nations. Federal recognition of an Indian tribe means that the federal government acknowledges, as a matter of law, a particular Indian group as a tribal nation with a government-to-government relationship with the United States. The Bureau of Indian Affairs, BIA, publishes a list of federally recognized tribes that can be found online and in the Federal Register.
As the Supreme Court has long recognized, treaties are not a grant of rights to the Indians, but a grant of rights from them. In many of the treaties that tribes entered into with the United States, tribes ceded land and natural resources to the United States in exchange for certain payments, goods, and services, the specifics of which vary significantly among the different treaties. At the same time, tribes often expressly retained specific rights that they already possessed before they signed the treaties, such as rights to land, to fish and hunt on ceded lands, and to use water. In addition, tribes implicitly reserved all rights that they did not expressly grant to the United States in these treaties. Treaties also implicitly reserved all rights that the tribes needed to carry out a treaty's purpose, for example, creation of a homeland. These principles serve as the basis of the reserved rights doctrine, a doctrine that governs many tribes' water, fishing, hunting, and gathering rights, which we will discuss in the next episode. Let's delve a bit deeper into the historical fabric of treaties between the federal government and tribal nations. The first formal treaty between the U.S. and a tribal nation was with the Lenape of Delaware, signed on September 17, 1778. The treaty was, among other things, a mutual defense agreement that allowed American troops to pass through Delaware land to attack the British fort at Detroit. In exchange, the Americans promised to build a fort on Lenape land for protection and to provide trade goods.
During the late 18th and early 19th centuries, treaties took on new significance. The fledgling U.S. government sought to establish clear boundaries and secure safe passage for settlers. In 1787, Congress enacted the wide-ranging Northwest Ordinance Act, which included a guarantee of tribal land rights. It directed that the utmost good faith shall always be observed towards Indians. Their land and property shall never be taken from them without their consent. It paved the way for a series of treaties with tribal nations, addressing land cessions and establishing a framework for coexistence. But treaties were not always used to promote peaceful coexistence. The U.S. government also used treaties as one means to displace Indians from their tribal lands, a mechanism that was strengthened with the Removal Act of 1830, which President Andrew Jackson signed into law. The act provided for removal of tribal nations from their ancestral lands in the southeastern United States to lands west of the Mississippi River, particularly to present-day Oklahoma. The primary motivation behind the act was the non-native desire for the fertile and resource-rich lands inhabited by the Native American tribes. With the act in place, President Jackson's administration used bribes, threats of withholding payments, and military or legal action to effect nearly 70 treaties for the involuntary removal of many tribes. In one of the most infamous examples, the United States signed a removal treaty with a minority faction of the Cherokee Nation, which Congress ratified by a single vote despite the objections of the Cherokee National Council. When members of the Cherokee Nation did not comply with the treaty, the U.S. Army evicted more than 15,000 Cherokee members from their homes. Best estimates are that 3,000 to 4,000 died as a result of the brutal forced march that followed, which is often referred to as the Cherokee Trail of Tears.
This is just one example of forced removal. The late 19th century witnessed a series of treaties, many fraught with challenges as the federal government sought to relocate or confine tribes onto reservations. In 1871, Congress enacted a law that eliminated the executive branch's power to make treaties with tribes. The law acknowledged that the obligations undertaken by the United States in the treaties it previously ratified remained valid. While treaty making ended in 1871, the United States continued to recognize tribal rights in other ways, including through executive orders, laws, and court decisions. In total, the U.S. ratified approximately 374 treaties with tribal nations. These treaties were not always entered into voluntarily by tribal nations, as noted previously. Additionally, sometimes a tribe would sign a treaty with a government representative and act in good faith based on the treaty they had negotiated, and then Congress would fail to ratify the treaty. Unratified treaties are not binding on the United States and do not have the force of law. While Congress retains the power to extinguish, sometimes called abrogate, or narrow a treaty through legislation, the Supreme Court has recognized that Congress must clearly express its intention to do so. Otherwise, the treaty will remain in force.
Especially when you adopt our financing proposal with needs-based budgets. Goodness cheesh. Thank you.
Tribes and the federal government still look to treaties to navigate complex issues. For example, the treaties that the various tribes in the Pacific Northwest negotiated with the United States reserve certain rights to fish. These treaties play a key role today as the signatory tribes of those treaties serve as co-managers of fishery resources with the state of Washington. Similarly, the Supreme Court has affirmed that under the Treaty of St. Peter's of 1837, which the United States entered into with several bands of Chippewa Indians, the tribal nations retain hunting, fishing, and gathering rights on land ceded to the United States. The Supreme Court rejected arguments by the state of Minnesota that these rights had been extinguished or revoked by subsequent actions. There are many such examples across the United States of the continuing significance of the agreements the United States made with tribes, and we will explore this more fully in Episode 4.
If you know that there are tribes with present-day or historical connections to the area where you work, or specific tribes that are otherwise affected by the work that you do, you should find out whether those tribes have treaties with the U.S. so you can better understand how those treaty rights could affect your work. Others in your office, such as tribal liaisons or your legal team, can be a good resource for this. In addition, if a tribe contacts your office and says that its treaty rights are affected by an action or proposed action that your office has taken or is considering, you should reach out to agency attorneys and tribal relations staff as to how best to address the issue. You should also reach out to these experts if you have another reason to believe that tribal treaty rights may be affected by your action. If you are interested in learning more about treaties, There is a comprehensive database of treaties at treaties.okstate.edu. Treaties are also included in other primary sources collections like Charles Kapler's Indian Affairs, Laws and Treaties, and the United States Statutes at Large. With that, we conclude this episode, and you are able to do the following. Explain the historical context and significance of tribal treaties, recognizing their importance in defining rights, establishing responsibilities, and protecting tribal lands and resources. Recall that the United States supports tribal sovereignty and self-determination for, and has a trust relationship with, all the tribal nations it recognizes. These treaties are living documents with lasting impacts. You are now equipped for the next portion of this journey. Join us next time as we explore the important concept of reserved rights.